Hello, everyone, and welcome to a very special episode of the Employee Handbook, an HR podcast by two lawyers, which I don't even know how this happened. Ryan, welcome, I should say. First off,
thank you. Nice to be here. Long-time listener, first-time caller.
Ryan, tell us why you're here today. What do we owe this pleasure to? Let the audience know.
I have going to make I'm in prison joke, but I'm not going to do that. We're here to talk about 2026.
Yes, we're here. Ryan had court today. That's what he was trying to make a joke about and just failed miserably. But Ryan had court today. He didn't get arrested for anything this time. But we wanted to talk about the 2026 laws that are coming in because we still get downloads every once in a while. So we thought we owed the remaining people.
Thanks, Mom.
Yeah, thanks, Mom. Actually, my mom has not even listened. She has not bothered to. She told me she did, but I doubt it. I didn't see any listeners from where she's from in the city, so I knew it.
No, and I think it's really been on us. I know that both of our sides, Arta and my work, has been crazy, and we apologize for not doing these more often. But we definitely want to get back on the podcast train and keep these coming. We know we've had some good feedback. We've had some emails, some calls, some messages. So we want to keep it going. And apologies from our end, so we can get this back on track.
That's right. I've been doing a lot of karate in the garage. That's been taking up most of my time. Also, I came up with a new business idea for it's a store that sells suppositories. It's called Whole Foods, HOLE Foods. But anyway, anybody want to get back to me on that? I'm available.
I love it, the HR podcast. I love it.
HR, yeah, exactly. Is that what we're here for? Yes. So what we want to do, new laws in 2026, we're going to read off the laws, attempt to make some jokes about them and be funny and stuff. And hopefully you guys will like it. So Ryan, you want to just start reading the list?
Yeah, let's do it. So one of the biggest things that I find in California, and again, just to remind you, we are lawyers. We are not your lawyers. So anything that we talk about on this podcast is not legal advice. We would love to help you out with your legal issues or non-legal issues, but that would require a further agreement and consultation with us directly. So please, this podcast is for entertainment purposes only. Do not take this as legal advice or really any kind of advice for that matter.
Anything you do, check with your own lawyer first.
Yeah, or call us. But let's just make sure that we meet all.
No, don't call us.
We meet all of the disclosures before. But so one of the things that I find very interesting about California, and again, we're here located in California, is wage and hour law, because not only is it insanely expensive to live in California, to pay taxes in California, but also as an employer, you have to pay an astoundingly large minimum wage that continues to grow. That to me, as a business lawyer and business person myself, is just insane. I understand the arguments of both sides, so please don't attack me in the comments. But paying somebody $16.90 an hour as a minimum, again, with other localities and other certain businesses or types of businesses being higher than that, it just blows my mind. So there's my lead into wage and hour as of January 1st of next year, 2026. California's statewide minimum wage goes up to $16.90 an hour. And in places like San Francisco, it jumps to almost $20, $19.18. In San Jose, where I hear they have a hockey team, but I'm sure it sucks, is $18.45.
Well, I think part of the unintended consequences, I think the raise in minimum wage also would make people ineligible for federal benefits. So they actually end up losing a lot of the federal benefits that they may get because of the wage going up. It's a very difficult topic. It's not something that we're planning to solve here. I'm doing more karate in the garage. And JP, what is this dance move you're doing? JP is our producer / lawyer who's
even crazier in California is that the minimum wage is even higher if you work in fast food.
Oh, $20 an hour for fast food workers. But I will say McDonald's near my office has gotten so much better. It's like Ronald has been on his game.
Well, it's also the oldest location.
No, not that one. It's the one up the street. Yes, but we are next to pretty much the third McDonald's ever and the longest operating McDonald's still operating in continuous operation.
And speaking of McDonald's, I just want to get this off my chest. California minimum wage has made McDonald's extremely expensive. I was in Texas in July. I went to the same McDonald's every day. I ordered the same meal every day. It was $6.90. Okay, $6.90. I come back to California, get the exact same meal from McDonald's a mile or two from my house. Guess how much that meal was? Don't guess. It was $12, almost double the price.
That's kind of crazy. Okay.
The exact same thing. So my point is that, again, I understand the arguments for why minimum wage should be higher. I may or may not agree with that. But like California and taxes and wages and whatever, it makes everything so much more expensive. It's insane. But to continue down our wage and hour rant, salaries, the minimum exempt salary went up to $70,304, which is $5,800 and some change a month.
What does that mean, though, the minimum salary? Explain to our listeners why that would matter.
Right. So to be, I guess, properly classified for a white collar exemption in California as a salaried employee, one of the elements of that classification is the pay you get, the minimum annual salary you get, or monthly salary. And now that has gone up again this year, 2026, to $70,304.
And why that matters is, so if you pay somebody salary, you don't have to give them lunch breaks and rest breaks like you would somebody who's paid on an hourly rate. That's the main thrust of it.
The biggest thing. And there's a lot of more benefits of having salaried employees, but also with the downfall of how much it costs and other sort of compliance issues if you get caught with a misclassification lawsuit or allegation. Apparently also the specialized exemptions went up for computer professionals, which is almost double of the minimum salary. It's $122,573.13, which is almost $60 an hour. And licensed physicians must earn at least $107.17 an hour. You'll notice that teachers are nowhere on here, people who teach everybody how to become these professionals. So again, our priorities are where they are in California. And then the biggest thing that I noted here, because we litigate these, Arta on the plaintiff side and myself on the defense side, are wage and hour claims and wage judgments. You see, if an employee is misclassified, or you don't pay them overtime, or you don't pay them enough minimum wage, you get sued, the company gets sued, there's a judgment, you have to pay the judgment. But now, according to SB 261, employers who fail to pay final wage judgments 180 days after them being entered can face penalties, again, additional penalties beyond what you probably had to pay to get to that judgment, whether it's LWDA fees or attorney's fees or whatever, of up to 3 times the judgment amount. So I think if we didn't guess already and didn't know already, California specifically, you need to pay your employees. If you don't, you need to pay the judgments that you get against you for payment of those employees. Arta, your thoughts?
It's going to get expensive to screw over your employees in California if you get caught. Luckily, I think less and less employers are getting caught. Well, luckily for employers. It gets messier because now there's another labor code that's coming up. It's expense reimbursement, labor code 2802. If an employee works at home in California, then they must be reimbursed a reasonable percentage of their internet, phone, electricity. So this is a big class action risk if you have a lot of remote employees, and also brings a very kind of difficult equation into this. Well, what is reasonable? Like now you're going to have to do like a calculation for every employee. Well, how much time do they spend on their internet? How much is it better? Well, how do you do that?
Do you have AT&T? Do you have Mint Mobile? What do you have? Like right. If AT&T costs $300 a month, Mint Mobile might cost you $35 a month.
Brian, if I'm a small business owner and I call you and I say, what the hell do I do with this? What do you tell them?
Leave California.
Leave California.
This will evolve through the case law, but just like with cell phone use, you can establish reasonable payments. I think they're anywhere between $25 and $100 a month for cell phones was deemed appropriate. Don't quote me on that, but the same is going to happen with internet. It's just, again, we should have expected this one, because you have to pay for everything else an employee does that you make them use. If you make them use their own lipstick, then you have to pay them for a portion of the lipstick. You make them use their own cell phone, you pay for their cell phone. You make them use a notepad from their diaries, you have to pay for that notepad. Anything you require them to use that you don't provide in the fancy word for carrying out their duties in the course and scope of their employment, you have to pay them for. So we should have expected this coming, especially with the post-COVID, rampant at-home work. And then, 5 years later is not surprising given how fast, and I use that very facetiously, how fast the government works to make new law.
Ryan, you really sound mad about taxes this year.
It's insane.
Here's one that is effective January 2026, which is actually a good one by California. California is banning stay or pay provisions in contracts. So a lot of companies are very predatory, and what they do is they tell employees that we're going to train you, but if you leave before a certain amount of time, you're going to have to pay back training, supplies or the cost of training or whatever it is, for a certification if they paid for you to get one. They could say you have to stay here for 2 years or pay me back. So now, after January 1st, that's illegal in California.
Not surprising. Pretty soon, employers are going to have to handcuff themselves to a desk if the employee's direction until they get paid, until they do what they want, take all the breaks they want, do anything they want, have to work.
Right.
I mean, this podcast is really for entertainment purposes, and I can rant about what I see in the course and scope of my work. And you see the craziest lawsuits. A lot of them are valid, but a lot of them are also invalid because they're either predatory on behalf of attorneys or because, shakedown from a person who's trying to prove a point or make a principled argument. At the end of the day, like, this has to stop. It has to stop somewhere, and it won't because it's California, and that's just how California is. But I mean, at a certain point, you're not going to be able to work in California without insane insurance policies, which they probably won't sell, to cover you for you do the wrong thing at the wrong time, and then you lose your third child. It's crazy.
But what about, like, let's say there's like a predatory company, because like there's companies that will pile 20 teenagers into a van over the summer and make them go around a neighborhood and sell newspapers or knives and stuff like that. And you have these types of companies that basically their business model is just to shake down their own employees. And I think this is probably more targeted towards that. I think, Ryan, what you're talking about is probably also very valid. Well, not probably, it is very valid, but you're probably talking about, say, companies that are spending a lot of money to pay for certifications for, high-level employees who will just leave. And I think that's a very valid concern.
Yeah. Well, just to kind of, you're right. Like, obviously, I'm completely against any business that takes advantage of its employees or harasses or, discriminates or retaliates against employees like that. Anybody should be against that. Anybody who comes up and says, hey, I'm for retaliation and I'm for sexual harassment, send them back to the 1950s where that was okay. Like, none of that's okay. But like, at the same time, just like I say about lawyers, like, I don't like good lawyers getting punished for being creative or for doing their job. But I do like seeing bad lawyers and predatory lawyers getting in trouble because it makes us lawyers, the good ones, look bad. Bad apple, bad bunch. So what I'm trying to say, and I'm not doing a good job of saying it, is that I want to see the enforcement of the law, like in the nature and the intent of the law, not for a creative attorney who is doing it for his or her own personal gain, as opposed to helping the general public or the clients to take advantage of a law, again, for that monetary thing. So with your kids in a van example, because that was actually a thing in college when they said, oh, we'll give you $200 a day if you paint roofs or paint houses. Like, if you did that, then yeah, there's probably a lot of employment violations there. But, at the end of the day, that you kind of expect that with that kind of employment. If you're working at, like in a business context, you kind of expect to not have to pay out of your pocket for things. But don't tell me you don't want to come into the office and then you want to work at home, but then I have to pay for you to work at home. Those kind of
pay for the internet. Yeah, I think it's very difficult. I think because there's such a balance as the state. You want to protect the employees from getting taken advantage of because of how easy it is to scare people who are, say, like illegal immigrants or undocumented, I should say, or just people or younger people who might need a job, seasonal work, things like that, and overly legislating every type of non-formalized work out of the economy. But California does allow like people to be street vendors and things like that and not have to set up.
Well, that's the funny part about California. In my example, I don't know the laws, like the exact laws, but there's a law in California where you can't disturb an encampment on the sidewalk, but you can get a ticket for parking on the street next to that sidewalk.
Yeah.
So it's like you can camp out on the sidewalk, but you can't park 2 feet over to the left of it. Again, crazy. I understand, again, the differences of public and private property, and I understand the differences of enforcement and whatever, but still, like, it's California is just, it's insane.
Let's see, what else do we have? Here is probably one of the most burdensome laws that I've come across, which is the California Workplace Violence Prevention Plan law that came into effect a couple years ago now. I don't know, you don't hear a ton about it. It's like a glacier because below the surface, it seems like there could be a lot of potential litigation coming for companies. So, Brian, do you want to explain a little bit what this workplace violence prevention program is and why companies need it?
Sure. So my understanding of the Workplace Violence Prevention Act is you're required for certain employers are required to take logs of certain activities that happen in the workplace as a broad stroke. And that the new laws that are coming into play are actually increasing the enforceability and the I guess the teeth to that law to make it more, well, cynically, to make it more palatable for attorneys to take these cases and for the government to get more money through its attorneys or through using private attorneys instead of the understaffed government. But so yeah, so some of the changes are, I guess, did you say 553? Or not?
I don't think I said it, but yeah, SB 553 was the name of the whatever the bill,
right.
And then
so the first one is being you can receive a penalty of $25,000 per violation if a qualifying employer or an employer who's subject to these workplace violence protection laws fails to log 5 separate incidents, which obviously in a bigger company.
No, that's per incident. I think it's up to, I think the notes were up to 5 incidents. It could get really expensive. I think was the point. I think it's $25,000 per incident.
Yeah, per violation. Did I say that wrong? I'm sorry. I said per violation, then I immediately contradicted myself in the next sentence. That's my fault. You are correct. And then worse, if whoever the inspector is, that clearly is not going to be biased towards the government, finds that you knew about the law and ignored it, and you used essentially willfulness in any way, your penalties can be adjudicated up to $158,000. So again, small beans for California employers who are currently just printing money.
Do you think that this could possibly turn into a PAGA claim? Where it's a PAGA is Private Attorney General Act, which is something unique to California, where California lets private attorneys basically prosecute on behalf of the government and the employee at the same time. And California takes a big chunk of the fees or the awards, I should say, the damages.
Yeah, so that's what I was alluding to earlier, is that so under PAGA, essentially the government is deputizing private attorneys like you or me, who essentially bring this case on behalf of the government. And if and when you prevail, you take a percentage of those fees and pay those fees to the state. So it's like you're, for that one case, you're a deputy private attorney general. So yeah, you're right. PAGA is part of 553. And if you fail to maintain your logs, then essentially you're in violation. You're in violation for each pay period you're violating. And just to be clear, the statute on that SB 553 is Labor Code 6401.9. But yeah, so worse, again, PAGA, if you have, let's say, 50 employees and you have 1 violation, that means every pay period you have 50 violations. So if you have, again, 10 pay periods, now you have 500 violations. And again, the penalties per violation, here for PAGA specifically, the penalty for violations are 100 per employee per pay period. So again, if you do a full year, let's say an incident happens on January 1st and you don't log it, either you don't keep a log for the year, 26 pay periods over the whole year period, for 20 employees at 26 weeks, again, 26 pay periods, at $100 a person, that's $52,000 in penalties, plus attorney's fees you're going to have to pay. So these penalties add up quickly and really are hard to dispute. And I think that's the purpose of PAGA too, is that PAGA applies to wage and hour claims. So like if you, as an attorney, you can look at a wage and hour statement and see that it does or does not contain one of the 9 or 11 things that are required to be on that pay statement. So this is just one of those things where you can easily find a log, you can easily find if they complied or not, and you can easily then have a lawsuit for PAGA to be and use that leverage to get a bunch of money. And I say you being the attorney or the state, because the person isn't going to get any of that money.
But they're not important. They're just a vehicle or a vessel for the arm of justice. But we're finishing up part 1 right now. And part 2, we're going to get deeper into the workplace violence prevention program thing. We're going to tell you the things that you need to do and the documents you need to keep, a little checklist, as it were. And we're going to tell you some incidents that you need to log that you might not thought would have fallen under the purview of this program. But here we're going to go to commercial. We want to thank our sponsors, Brian Ellis Law Corporation, awesome lawyer in San Diego who I have no affiliation with, no idea who that is, but he's great. Anyway, we'll see you for part 2.
Part 2.
We're back.
Dun, 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 dun. Do we have a jingle yet?
And we had music. I don't know. I've never actually listened to the podcast after this. I have no idea. I think we're probably repeating stuff we talked about before. But anyway, yeah, we still owe a company handbook episode, right? That's like we have like an inside joke.
I also don't listen to the podcast.
I don't mean.
But no, we did make some promises at the last one, so we'll have to follow that back up.
Okay, I remember I promised some lady something, but lady, I don't remember. Okay, so workplace violence prevention program. What should we do first? Should we talk about situations that are going to fall under this, or should we talk about the stuff that you need to do and have and all that crap first?
Which one is funnier and more cynical to talk about?
I would say, oh God, because people are going to stop listening in about 30 seconds. Let's do the examples because those are going to be funnier.
Okay, let's do it.
Okay, first example. I don't know where it is. You read it off your paper while I look for it.
Is it the Slack one?
Yeah, I think that one's good.
Okay, so let me give you an example, and you tell me what the mistake is and what you do about it. So you have 2 employees. They're fighting. One of those employees sends a Slack message to the other one. You better watch your back in the garage tonight. Now we're going to assume that there is an actual garage at the workplace.
Okay, that's fair.
And he's not, stalking somebody. So let's get rid of the stalking part of it. Let's get rid of the assault and battery. That could happen in a private garage. Talking about at your auto shop, one of your employees goes from the car to this computer to this Slack message to his coworker and says, "You better watch your back in the garage tonight."
Yes.
Go.
Well, obviously, this is going to be an issue that you're going to have to log in this thing, in this violence prevention program log, or incident log, I should say. And then you have to put a copy of this log page or whatever in redacted form into the employee's personnel file, so it can get reviewed by them later. So,
well, what's the difference of keeping it only in the personnel file versus putting it in or on the violent incident log?
I think you have to do both. I think if you keep it only in the personnel file, it doesn't get counted as in the safety audit when you have to do a safety audit of yearly safety audit of your effectiveness of your workplace violence prevention program, which I'm sure doesn't take any time at all, on top of all the training you have to do. Because if you don't train your employees and something like this happens, then you're probably on the hook for willful conduct, and you're looking at that $158,000 fine.
Yeah, and I think this just is a reminder to not throw away your basic HR instincts. Like if my garage employee walks to the computer and threatens another employee on Slack, that clearly is an HR issue to deal with, and you should probably keep that in the file, the employee's file, right? But then now you just have that additional requirement of logging it and keeping a redacted version
that employees can look at.
Look at, which again is going to be so much fun for talking at the water cooler, and it'll be so good for morale when again, I want to use a name, but I feel like using a common name is going to get us some pushback. But like when Peter from accounting goes over here and starts saying, "Oh, hey, did you hear about the complaint where somebody did X to Y?" Like and then it's just going to start a whole drama fest. So yeah, this is going to be a fun one to see how this evolves in the courts.
Yeah, absolutely. But if you're the plaintiff's lawyer, you're going to say, well, look, like you knew about this and you guys were supposed to keep a log and you hid it, and maybe my employee should have known to stay away or whoever, you know what I mean? It just
agreed. But at the same time, and that's a very valid point. But at the same time, if the names are redacted, like Brutus assaulted Peter on Slack, and you don't know it's Brutus, you don't know it's Peter, your employee, your potential plaintiff would only know to stay off of Slack. But wouldn't know to watch out for Brutus, who's apparently trolling the garage at night
to beat up people. Yeah,
beat up people. You know what I mean? Like, I get why it's redacted, because you don't want to have all of that out there. It's supposed to be kept confidential. But then if you're going to have a violent incident log that's public, quasi-public to your employees, like what benefit does that provide? Like meaning what proactive benefit does that provide to a potential, there's lots of alliteration with P in this sentence, to a potential plaintiff who may or may not be concerned, or maybe had a personal issue with Brutus and didn't want to report it, but know it's going to happening again. Like what, as like a point of discussion between us, like what, I don't understand that.
It just complicates everything way too much by having to keep these logs, I think, available for everybody to look at, because it's just going to cause so many just questions to be asked and wondering, what's going on and what could be the cause of this. But at the same time, I mean, it's easy to see how a jury could want to keep a company liable for hiding the fact that there's been lots of violent incidents at a company from the other employees. JP is raising his hand.
Yeah, I mean, there's so many tangents that this can go off on, but one of the things is I think this is a very short-sighted win for the plaintiffs, because in the longer, you've now established a written record that most people don't actually keep for a legitimate basis for termination. So you're no longer going to have as many wrongful termination cases, because you're going to have a log of all the times that people potentially actually made threats against them, even though they didn't act on them.
Yeah, and that's very true. I think a lot of problems we have with plaintiff cases, that we'll have a plaintiff client come to me and say, I was threatened by an employer, or, I was punched at work or something, and there's really nothing that we could do. I mean, you could have negligent hiring or negligent supervision and things like that, but now if the employer doesn't log the incident, they could be looking at $158,000 in fines. That also helps you as a plaintiff's attorney to prove that the employer didn't take it seriously, the incident that happened to your client, and now there's going to be a way to hold them accountable for it.
Yeah, and I guess as a defense lawyer, it just makes more billable events for me.
Yeah, it works out.
Let me review your policy. Let me review your log. I mean, then I guess maybe that too, though. And this to me is like, the log is like the posters in the break room that no one looks at. Like, oh, this is the minimum wage. This is the rule. This is what you have to call if there's an emergency. All that crap. Like, yeah, it's required, but no one really looks at them, right? So my thought is that if no one looks at it, there's no point. One. But two is, if someone does look at it and they see, like, let's say, you hire employee A and it's their first day, and they meet everybody. There's 50 people. They're in an office, a bunch of computers. 50 people are in the office with them, whatever. The employee A, everybody goes to some birthday party. So employee A is like, no, I'm going to stay here and work over lunch or just hang out by myself. In the lunchroom, employee B or employee A sees this log. They just got hired, and there's like just voluminous records of like violent incidents or incident reports. Like, what do you do as an employee? Now, are you worried about being in, like, is this going to create apprehension for an employee?
Yeah, I would think if there was a whole bunch of incidents, it definitely would. But that's one of the other things, is that, what is the whole point of this? And why did this come up? I don't understand really why it became necessary for there to be a published log for all the violent incidents. It doesn't really make a lot of sense. But we want to talk about maybe a couple other scenarios of what could be reportable. Let's say you're at a coffee shop, Ryan, and you're the manager, and one of your employees comes up to you and says, "Oh, I got yelled at by a customer who slammed his hand on the counter and told me they were going to come kick my ass." Is this something that falls under the workplace violence prevention program incident log?
Yeah, it does. I think there's a specific numbered category for this, but I think so. You need to report it, and if you don't, you're subject to penalties. I mean, this kind of goes to the whole, I don't know if laughable is the right word, but like, do you think that someone is going to be able to remember all of these incidents, especially in like high pressure jobs like sales or coffee? I mean, I don't go to Starbucks or any other coffee shop in the morning anymore, but I would assume that people who don't have their coffee are very irritable in the morning, maybe are very brutal with their words and potentially threatening because of it. If a coffee is wrong that they paid $13 for. So, I mean, I would think that if that happened 3 or 4 times in the morning, like, who's going to report that to your manager? The manager's going to have to put that in a log. Like, that seems very unproductive. And you can't do it after business hours in California, because what happens then? Overtime. So it's like there's just so much here that seems like it's almost like a trap. It's almost like an unenforceable trap.
Oh, absolutely. I mean, I think part of the thinking is that this gives employers like an ability to say, "Oh, look, we logged it, so we took it seriously." to take the legs out from under some of these he said, she said claims when, let's say, there's an investigation that the employee didn't like the outcome of. I think that's really something that the employer could be like, well, look, we did do an investigation. We did look into it. They're lying because, look, here, we wrote it down on this log. Brian, why don't you give us an example of a recent lawsuit that you just happened to have in front of you?
Thank you, Arta, for that. Surprisingly, I have one right here. It's Espinoza versus Target. It's an ongoing case in Los Angeles County here. There was a ruling in February of 2024 where the plaintiff alleges that Target acted unfairly and unlawfully when Target denied plaintiff a safe shopping and work environment, denied him the benefit of a legally mandated workplace violence protection program, and the ability to abate illegal and violent activity, such as detaining a potential violent patron from entering the Target store, which also prevented the plaintiff from the ability to obtain a restraining order and being able to deny himself the right to defend from criminal activity and report it, which then, as a result of all of that, caused an unsafe work environment for that plaintiff and others. So there's the, it sounds like to me, low-hanging fruit claim, is that because you didn't have the policy, again, this is all before the new laws, but because Target didn't have or maintain their workplace violence protection program, that the plaintiff was subjected to some sort of injury, which then could have been prevented and should have been prevented, but for the existence of and maintenance of that violence protection program. So again, I don't know how a California business or any business for that matter is going to be able to hire somebody to just walk around with their clipboard and report everything and then keep, for companies like Target, a very voluminous, probably electronic, which is probably illegal too, electronic means of keeping all of this in order. So if anybody wanted to review it, they could, and again, prevent themselves from being harmed. But again, it's redacted. So
what do you really hear? Yeah.
What are you going to know? Like, what is the plaintiff going to know? Is they going to know that 55 different times within the last 2 months, somebody was attacked at the register? Like,
well, here, I'm going to give you another example of what could happen if you're Target. You have an employee who has, say, an abusive ex show up to the parking lot to argue with them, and the employee leaves the store to go argue. And you're thinking as a manager, well, what the hell does that have to do with me? It was outside in the parking lot. It has nothing to do with work. It's just one employee, like basically taking like a break, 10-minute, like, go, I don't care what you do on your break. What if you go argue on the phone on your break? What the hell? Mm-hmm. But it must be logged. Violence committed by someone who has a personal relationship with the employee is type 4 violence. It must be logged. So by failing to log it, you're essentially, I guess, under what the law is considering failing to kind of secure the perimeter. If he comes back, the ex-boyfriend actually hurt someone, the plaintiff's attorney is going to say, oh, okay, well, you knew about this threat. Like, why didn't you do something about it? Why didn't you notice her going out again or whatever it is? Where is this log? Now you're in trouble. But like I said, I don't know what the line is. If she's on a private call, or how are you supposed to know? Does she have to come and tell you like that there was an issue with her boyfriend? Or is it something that you're the manager and now you have binoculars from 150 feet away and she's gesticulating and you're like, well, I can't hear what they're saying, but it looks like a fight. So do I now have to stop her and be like, hey, were you fighting with your boyfriend? And she's going to be like, well, what is it your business? And you're like, well, California says it's my business. So, I think it's going to cause a lot of problems.
Yeah, agreed. I mean, I guess practically, so all jokes, obviously a lot of this is ranting and joking, but practically what has to happen or what your policy should say is that if you experience workplace violence, you must immediately report it to your supervisor or manager or HR or security or somebody else, giving that person you're reporting to as much detail as you can of what you observed or experienced, so that management can management can document it and put it in a required log and take action as necessary. So practically, this will not work. But it's one of those things where you experience it, you have to report it, and then which then again begs the question of, well, if you don't report it, does the employer know about it? Which also begs the further question:
constructive notice, which we had another episode on.
Constructive notice, yeah, good plug. But also ratification when it comes to willfulness and punitive damages. So in your same example, if that employee outside is on the phone call and experiences something outside, let's say it's an ex-boyfriend or ex-girlfriend or ex-partner comes over and I don't know, does something violent, says bad words, physically touches, pushes, hurts, whatever, and that is not logged. At what point in time does the manager have to step in if they see something? At what point in time does later on, if that same situation happens again and the person outside the employee is actually hurt and they sue the employer, does that constitute punitive damages because the employer knew or should have known? Or if they didn't have a policy, does that automatically create ratification of whether or not they were, if they didn't ratification date where they actually ratified that conduct by not having the policy or not reporting it, which then subjects the employer to punitive damages.
Well, this is the joy of judge-made law, because that's one thing that people don't understand is that we're all kind of just fodder for this machine. So the way, in my opinion, the way that the judicial system works in the United States is that all 50 states have their own judicial system that deals with similar issues. After 20 years, 30 years, 40 years of, say, laws about the same issue with competing ways of dealing with them are looked at, then maybe it'll go to an appeals court in the federal circuit to decide what's the best way to handle an issue like marijuana or something like that. But that's very unsatisfying for the people who are left as the mulch from the machine grinding up everything to figure out the best way to do things.
Yeah, agreed. And that's very well said, is that this is going to evolve very slowly by judges' decisions, by appellate court decisions on those judges' decisions, by the state Supreme Court decisions on those appellate court's decisions on those state court decisions, and possibly the federal Supreme Court, depending on how bad it gets. But it's going to be interesting. And then you'll have California stepping in next year or the year after, codifying some of those decisions that the government liked into law, and then it evolves from there. But just to kind of, I don't know if you want to go over more examples, I want to go over what the employer should do.
Yeah. We got to talk about that. Also, workplace violence prevention program, just quickly, you have to go onto the California Department of Industrial Relations or some website that California has and download the template and then customize the template to your business. You can't just download it and sign it. You have to go in there and actually customize it and talk. Like if you don't put like the door is on the east side of the building and there's like an access point, like you're not gonna conform. You got to go find a lawyer. Actually, I know where you can find a lawyer to help you with this.
I feel like we have a sponsor.
Oh no, I can't remember his name. Anyway, part 3 coming up. Back. We're just going to quickly tell you the stuff that you need to do if you're a business for this workplace violence prevention program, because that's the only thing I can think of to do, and we want to get the hell out of here because we're getting bored.
Not bored. I mean, the problem with these podcasts is like we have to balance. This is behind the fourth wall for you listeners. Well, I'm sorry, you listener out there.
Yeah. Hi, Ryan's mom.
Is like we want to be informative and we want to give practical advice for entertainment purposes. We also want to be funny in a way that you'll want to listen to this third segment.
Yes, somebody please hire us. We're for sale. Like, I know nobody's listening at this point, but if you're a company and you want somebody to shill for you, we're here. We're lawyers. We're not like moral good people. Like, come on. I'm joking.
My mom was going to send me a nasty text.
Okay, so let's talk about the stuff that you need as a business owner so you don't get in trouble in California, even though you're going to get in trouble anyway. But here's the stuff that you need so you get in less trouble.
Yeah, I think you hit on the first part of it, which is having the policy by itself. And what is that? Well, obviously, I think you should, if you don't already, you should consult an HR professional or a legal professional to do that for you. Arta mentioned the template in the last segment, and that template I've seen is it's very blank. It's not even a skeletal template. It's more of like, insert your diagram of your business here. Insert this, if this happens, insert this here. It's very basic. So you really need to fill it out. It's definitely not a turnkey thing. I mean, it gives you very small guidance, but you have to actually do it.
It's going to take you a long time.
Yeah.
It's going to take you a really long time.
Yeah. Well, hopefully the people who are listening to this podcast know that there's something you have to do. It takes a while. Good HR policies take time. If you're not an HR professional or legal professional, then you need to get one. But after you have the policy in place, make sure it's conveyed to your employees.
You got to do training, like actual live training where they can ask you questions about what to do. Like this isn't something where you can just be like, throw it on their desk and say, hey, figure this out. My responsibilities end here. You actually have to give them like real training, not just a video.
Why do you say they have to?
Because that's what the law says.
I know. I let you right into that one.
There you go.
Because if you don't train them, then they're going to say they didn't know about it. It's same as like a sexual harassment policy. Like even though they signed something, doesn't mean that they actually knew what they were signing. And it's always a thing like, oh, I had to sign it to work here or whatever. So make sure you have a separate rollout plan or a separate like training module for your policy, your workplace violence policy, and make sure employees, like Arta said, can ask you questions about it.
I feel like this is also a really good way for insurance companies to be able to tell their policyholders that they did not meet the standards as required by law, and that either their policies are going to go up or they're going to lose their coverage, or just a whole bunch of expenses coming up.
Well, yeah, I mean, and I think you hit on a good point there, where if you don't follow your violence injury policy, then wouldn't the insurance company want to tell you that they're not going to pay for this?
Exactly. Yeah.
So another reason for insurance companies to get bigger, well, employers foot the bill.
Also, you have to annually visit every site in your company and review every incident that happened, and see if your plan worked. And you have to sign a review sheet. And if you don't do that, you are not checking the plan, and that's negligence.
Not in compliance.
So this is what we need to do. You need a written plan. You can't use a generic template. It needs to be customized with site-specific hazards. Like if you have a liquor store that people may come in and rob you, if you have a logistics place that maybe there's like a fight club after work with all the employees, something cool like that. I don't know. I'm just trying to come up with that.
I mean, it's very relatable.
That's cool, right?
Very client relatable.
Yeah.
But and then so also in addition to having everything, also to have that written plan. In addition,
to be clear, that violates Rule 1 of the Fight Club.
Oh, talking about it?
Yeah.
Oh, now I gotta like punch myself or something.
So aside from having the actual plan and reviewing it and making sure that you go through and audit it, you need to have an incident log. I know we've mentioned it in our obviously hilarious examples, but you need to have an incident log, and you follow the privacy rules. Make sure you don't disclose personal or confidential information in those logs, like names. And then above and beyond that, making sure you're training, making sure that you're letting the employees ask you about it, and that
and giving you input on the plan.
Yeah.
If they feel like you got to do something and you don't listen to them, and later on they said, well, I told them it's not a good idea to have like a whole bunch of axes hanging over me when I'm working at the register. And you're like, no, that's totally unreasonable for you to say that. And then axes fall, you're going to be in trouble.
But like California, especially California employment law, it's always axes. So if you are a manager or higher in a California employee in a California business, and you're not constantly worried about what lawsuit you're going to face next, you're probably not doing your job right.
Yeah, that's true. And we have nothing left to talk about at this point. Except for we want you to hire us to advertise for you. We will shill you to death. Just give us any money. If the Saudis are listening, the Qataris, any type of government that needs to wash their hands of violence or anything like that, we're happy to work with you.
I cannot electronically rub my head or my forehead in disappointment any harder.
What is it called? Sports washing? We can do podcast washing for like dictatorial government.
This is Pete Davidson going and doing the comedy tour.
So, Mr. Wildeboer, how did you get in touch with the Russian government? My podcast? Get out of here. See, no one will believe it. So
No,
it works.
well,
Perfect plan.
Next time a journalist gets cut up into pieces in Turkey, look for me.
It's Turkey now.
Oh, is it? Did they change the name?
They should change it.
We're going to have to really just scrub that whole part. Let's see. 1, 2, 3. Thank you, everybody, for listening. No, we'll leave it in there.
I scroll the whole part and scrub all
the whole
I was like, holy shit.
No, not Turkey.
Turn.
No. I'm Persian, not Armenian.
No, I know.
Yeah.
I was so confused. Like, oh my God, that was bad.
All right. We're going to have
Okay, start over. Go ahead.
No, okay, we'll just leave it all in there. Okay. Thank you, everybody, for listening to us. Nobody's listening this far. There's no one. If anybody listened this far, I will give you $100. If you email me, arta@wildeboerlegal.com, and you say, let's see, what Enrico Palazzo, email me the name Enrico Palazzo to arta@wildeboer.com. First person who emails me will get $100.
Arta@wildeboerlegal.com.
Oh yeah, my bad.
First person to email gets $100.
Arta@wildeboerlegal.com, $100 if anybody's listening to this. See you later.